The biggest piece outside of obviously working in each state to change the laws, working in each state, whether it be through lawsuits and federal court, to change the way the state operates in these courts. But I think maybe the biggest win could be if the movement was able to fully reposition itself to put it in the light of that. I had a conversation a couple weeks ago with an attorney, Ashley Nicole Russell, out of North Carolina, and we talked about, is this an issue? We know criminal courts. Any attorney that we've done CLEs, we've done law school classes where we talk about in criminal court, there's a huge issue with race. The darker your skin, the longer your prison sentence. Well, we don't have the data in family court because the states seal all of it.
Yeah.
I could almost guarantee you the same exact things happen in family court. And there's some kind of anecdotal studies that show that like black fathers are 3 times as likely to lose all access to their children as their white counterparts. But we don't get that raw data, or this movement or this issue would be completely reframed within society of today. So I guess what's kind of your thoughts on that?
It's hard for me to answer that. I mean, I can maybe, Mark, what I can do is I can go into an example of an unconstitutional policy in practice and how I think that that would be a real, if we got this implemented, let's say we moved and let's say we got the relief that we wanted from the federal court after several years, what it might look like, what family court might be different if we were able to go in federal court in certain circumstances.
Yeah,
I don't know.
What's yeah, I think that's a good turn point there. What's the output of these lawsuits? What's the output of carving out the ability for us to know how exactly to get into federal court with domestic issues?
So this is generally my view, and people have to understand, and because I've seen all these cases, and so many of these cases that are filed by people that are not attorneys. Okay, so I've seen that people make horrendous mistakes. They sue the judge, they sue their ex, they sue the other attorney, they sue the guardian ad litem. They're suing everybody, and they're basically going in and complaining that I got screwed in state court and trying to get an appeal. That is going to get you thrown out. That is not going to be, that is not a serious suit. But what I think that they are, what I personally think that the state judges are vulnerable to right now are suits in equity for mandatory injunctions by a federal court for violating a constitutional right. Now, a constitutional right is something as basic. Well, first of all, there's 2 elements to the constitutional rights that we have, okay, in these state proceedings. Is number 1, we have procedural due process rights for notice to be heard, for there to be a hearing, for there to be findings, and a fair adjudication under the law. Those are all rights that you have procedurally, and that could be. Those are federal rights that we have as individuals, individual federal rights, not given to us by the states, given to us by God and our constitutional founders. The other element is substantive due process, which has been sort of built up since the 50s and then really solidified in 2000 with Troxell versus Granville. It says that fit parents have a fundamental right to raise their children without interference by the state. Okay. Well, what's happened is that the state has interfered completely. What we have, and that's what the suit that I brought in the 7th Circuit, is that these are about civil cases between 2 people. The state is not a party. Big Brother is not in there to tell you what is in the best interest of their children. They're there to resolve a dispute between 2 people and determine what's in the best interest of the children in the context of the dispute, not for the state to come in and say, I think it's in the best interest of the children that they not see this or that they not see this. They're coming in on their own and making their own conclusions without a motion pending. Okay. So what they're doing in that case is they're making sua sponte orders. They're acting as enforcers, like they're the attorney general or they're the police. They're charging you, they're hearing it, they're not even listening to you, and deciding your rights on their own initiative. And there are egregious examples of that happening. That happened in Illinois, for example, with a woman who lost custody of her children, a woman, because she didn't have a COVID antibody shot. And the judge did it on his own. Well, you're not going to be with your son because until this was on his own initiative, and it was illegal. And he ended up getting international attention, national attention. He recused himself and he reversed his order. But anyway, that's an example of a judge exceeding their jurisdiction, okay, coming in and entering orders on their own. I believe that the federal courts would have the ability to enjoin those kind of orders because that is the judges don't have immunity to suits in equity. That's not a complaint for damages, and you're being immediate. You're subject to a preliminary injunction, temporary restraining order, immediate harm, no adequate remedy of law. There's all these things because the judge is coming in and being, playing multiple roles. And if you look at judicial immunity cases, judges are immune for damages from suits, but not from equity. For things that they do in their duties, in their adjudicatory duties in their duties other than adjudicatory. Sorry. So,
yeah. And I think looking at it, you look at. Go ahead. Finish.
Go ahead, Mark. No, I'm done.
I was going to say, I think that in saying that, I think that I've seen numbers anywhere between 70 and 90% of litigants in family courts are pro se, pro per. They're representing themselves, and I think that lends itself to creep. So the judges, when you have someone who's going to be in front of you 5 to 7 times or whatever it may be, and they're representing themselves, and you do that over and over again, and you're overworked, it lends itself to that judicial creep where they've taken more and more and more leeway in what they do. When you think about other types of law, if it's going to be attorneys, it's going to be a 5-year-long employment case, an employment discrimination case, or even something at the state level, state criminal courts where the person's going to have an attorney. It lends itself, the attorney is going to stop right there and say, you can't do that. But in family court, I walk into family court, let's just say the week after Christmas. There's a very distinct possibility that it's going to be me and 1 or 2 other attorneys, and there's 15 cases on the docket. And so how's that layperson able to say, no, you can't do this? Number one, they're terrified for their life. It's the most important thing in their life. And they don't really know what they're doing. So there's not as many attorneys to step in and say, Your Honor, you actually can't do that. And it's just become part of kind of the lexicon in family court is that creep and the ability just to really do anything and everything.